And what's interesting about Missouri is that it's what's called a pure comparative fault system, meaning that you can actually bear some responsibility in the accident and still recover for your injuries. And the truth is this, most accidents aren't as a result of one cause. Most accidents as a result of many contributing causes. So just because you may be 20% at fault in the accident doesn't mean that the 80% fault that the other driver had is not going to be something they have to compensate you for. Now, something that's critical to be aware of when talking about your rights in a case with long-term injuries is that there are statute of limitations. And for most cases, general cases, when somebody causes you to get injured by way of some negligent act, you have 5 years from the date of that accident. I say this cautiously because I also don't want to be too broad. There are causes of action that require you to give notice within even 90 days. I think what the most important takeaway from this is don't delay. The statute of limitations will bar you from bringing your action. And I think the worst thing that could happen is that you begin to recover, you wait some time, and you learn that you waited too long and can no longer recover from the harm that you've been suffering. Now, we do have to prove injuries. And when I said earlier that there has to be a foreseeable injury in the actual negligent act causing your injuries, we have to prove those things to the court. We, as the person bringing the cause of action or asking for compensation, bear that burden. And the way that we bear that burden is that we demonstrate it to adjusters and to defense counsel and to the jury by oftentimes showing medical records, such as notes from doctors or specialists or other healthcare providers that you were treated for or treated with after the accident. And hopefully those records will outline the nature of your injuries and the treatment you received, as well as any long-term effects that you've experienced. Now, there are some cases, though, that do require expert testimony. And in those cases, we do have to hire witnesses, such as doctors or even vocational rehabilitation specialists, who can testify about the long-term effects of your injuries. These professionals can really help impact the value of your case and make a clear picture to the adjuster, the court, or defense counsel as to how these injuries have impacted you. You'll also want to have documentation for lost wages. If you have a long-term injury and we're arguing that as a result of that injury, you've lost the ability to earn an income, you really will want to have the documentary evidence to show that that has in fact taken place.